Hi, everyone. First of all, I would like to thank you for the invitation. It's a great pleasure to be here during this event talking about mediation. And I am a certified mediator, and I would like first to introduce myself. My name is Liana Valdetaro. I am a lawyer and a mediator in Brazil, and I am specialized in commercial and business mediation. And I would say not only mediation, but what I like to do most is solving conflicts. Because as a lawyer, my profession, we need to solve the client's problem. So it can be through litigation, arbitration, negotiation, or mediation. And we are here to talk about business, import and export mediation, because we are in an event like this kind of business and this kind of aspect. And the topic I would like to reflect and I would like to share with you some ideas and some thoughts is the choice of the mediator, is the importance of the choosing the right mediator for the conflict and the international training standards for mediators. And why this topic is so important? Because when we look back to the mediator's role in opposition of arbitration, the mediator will not decide the conflict, will not judge, will not say one is right and the other is wrong. This is not the mediator's role. And what is the mediator's role? It is to help the parties find a solution for themselves. So the mediators talk to the parties, mediators helps negotiation, listen to the parties, and listening one party and the other parties in joint sessions or in separate sessions. In mediator's mind, he listens one piece, he listens other piece, and then is able to join the whole aspect of the conflict and applying communication skills, negotiation skills, talking to the parties, talking to the lawyers, is helping the parties finding a solution and finding a way to solve the problem. And this solution can be a solution much more open and creative than the judicial solution or the arbitral solutions. So to do that, the mediator needs a lot of training. And this training, as much as the training, the theory training or the practical training, hours of training, and I used to compare mediator as the pilots. Can you imagine the pilots training for planes or for helicopters is counting by hours. As much as hours of training and flying training is the same for mediators. So many and many hours of training, the mediator gets better and gets better in communication skills, in identifying the time to get a session paused and the time to separate the parties and the time to have separate conversation with the lawyers, and or getting back and joining sessions, or identifying the time to stop the session and restart the next day or the next week, or having the whole day in a one-day negotiation and mediation through the night. So this is experience, and not only experience, a lot of training and certifying trainers. And this training and this experience will get the mediator to a point of not only sharing confidence and empathy with the parties, building trust and building trust and credibility. And this is so important because talking a lot with lawyers, and myself being a lawyer, is coming to our minds, or to the minds of our clients, better saying, why do I need a third party to solve my problems? I already hired a lawyer. My lawyer is a competent lawyer. He already tried to negotiate with the other party and the other lawyers, talking to business. We are talking about companies, and companies have their own legal departments. So we already try to negotiate. Why this mediation, and how this mediator will do some kind of magic that will solve my problem in a different way? I already tried and was not able to solve the problem. So this is very important, because is a reluctant, is a barrier for mediation. This recognition, the need of a third party, and the mediator having this trust and this credibility from the parties and from the lawyers is a step well established for the success of the mediation. And why we are talking a lot of success of mediation and building trust and credibility? Because if we are able to solve the problem through mediation, we are saving time, we are saving money, and we are in a context of business. Time is money, import and export. We have this kind of conflicts. If we wait for the products and goods to be released from the customs and aduana, or for the payment of this or that, it won't be useful anymore. So being able to solve the problem in this kind of situations is very interesting and profitable, I would say that. And choosing the right mediator for the right problem means understanding the style of the mediator. And why I am saying the style of the mediator? Because we have a lot of styles. The same, we have a lot of lawyers' styles. In mediation, we used to say we have the facilitative styles and the what is this facilitative style? Is the style that the mediator is less intervenient. So the mediator listens to one party, he listens to the other party, he shares information as long as the parties allows him to share specific information, but the intervening of the mediator is softer, I would say this way, is lighter. And we have another style that is considered more an American way, this style, that is more intervenient. The mediator, he asks more tricky questions, he makes parties think about the problem, he can point out some situations and even suggest some aspects. I won't say he suggests offers and not the solution, but he is more intervenient. And this is another style of the mediator. So choosing the mediator will correspond the expectation of the parties to the mediation, what they expect from that process of mediation. The parties and their lawyers only want someone to organize the communication because they are shouting, they are not listening to each other, or they really want someone to stress out some points, to pick up some problems, or even to suggest maybe some different ways. I won't say this is the right way to go. I'm not saying this, but maybe have you ever thought about comparing the price of this or that? This is also very using mediation. So knowing the mediator style, researching the mediator through the lists of the mediation centers, through internet, or asking somebody, and the lawyers know each other, asking a colleague, how about this mediator style and how he works, and even interviewing the mediator is very, very normal. Having a conversation with the mediator before starting a session and asking about the style, about the work, about the dynamic and how the mediator likes to work, and hours, and even fees and mediators fees, and if there is written submissions, not written submissions. Every detail is important. Having these details understood, the mediation will go very smooth. And knowing you are in good hands is very important, because as I already mentioned, to become a mediator, it takes a lot of time, a lot of training, and a lot of investment. And for example, the Brazilian law and the Brazilian center, the Justice Center, requires the minimum of more than 40 hours of training and theory and practice. So each country have their own rules of the minimum to become a mediator. But what is common sense requires a lot of training, and specific training of the negotiation techniques, techniques of communication, techniques of listening, techniques of asking questions, techniques of asking the other party to put themselves in the other party's shoes, asking about creative solutions, considering hypotheses, a lot of techniques and a lot of tools to become a mediator. And this is different from someone who is already known for the parties, who already have the parties' trust, maybe is someone known in the market, and the parties ask that person to intervene and to help them to solve the problem. This person known and that have the trust of the parties might be a good mediator. Yes, it might be, but is not a trained one. It can be reached a good solution. Yes, maybe by lucky or because the party already are in a mood of reaching an agreement and in amicable behavior, but not being trained in the techniques of moving the parties from one position to other position. The only fact of that person share the party's trust and being someone known in the market in that field will not transform that person in a good mediator. This is the point. And besides these topics I am mentioning that is important for the success of the mediation, the style, the credibility, the trust, why this is also very important? Because of the Singapore Convention. And I don't know if you already heard about the Singapore Convention and what is these means of Singapore Convention. And then I go to my next slide. What is the Singapore Convention? Is result from the United Nations Convention, the task force, the business and commercial task force, and the Committee of the United Nations, studied a lot of years about the Singapore Convention, and is an international treaty to be able to enforce settlement agreements resulting from mediation in foreign countries. So, for example, if I have foreign parties, of course, having a problem, having a conflict, they go to mediation to try to settle that problem. The parties are international one because they have their business in different states, or both of them, or even one of them have their business in different states. They reach a solution. When, if happens, one party do not comply with the agreement, and the other one needs to seek the enforcement of the agreement, where will be able to enforce that agreement and to seek that enforcement? In both states, as long as the states have signed the international treaty. But this Singapore Convention is the objective, and the scope is to provide a secure environment for enforcing agreements resulting from mediation in international countries. And this Singapore Convention was signed last year. We still need to be confirmed internally in many countries. For example, I am a Brazilian, and Brazil only signed not long ago, only signed a year, but still needs to ratify internally in the Brazilian Congress. So is not enforceable so far, but we are in a way of being enforceable. But the most important aspect of the Singapore Convention, we in the mediation field and dispute resolution and conflict resolution, we expect the Singapore Convention have the same context or the same improvement of mediation that the New York Convention had for arbitration. Before the New York Convention, arbitration was considered to be, I won't say weak, this is not the word, but people are reluctant to understand arbitration comparing to litigation and to the courts. And having the New York Convention saying, okay, this is enforceable. The result of arbitration is the same of the judiciary, and you can go and seek there. It was an increase of arbitration. And we expect that with the Singapore Convention will happen almost the same with mediation. And why this is important in our context of import and export and business and commercial dispute resolution, because the Singapore Convention only apply for agreements resulting from mediation in writing for commercial disputes. It's only commercial. It's not for family, it's not for inheritance. No other aspects. It's only business. It's business oriented. And why is business oriented? Because we understand that in commercial disputes, we want to increase the commercial business between countries without the fear of having a problem and not being able to solve this problem. If we have an international environment of being able to solve disputes, because having problems sometimes in some way will happen. We cannot be afraid of having a problem, conflict, it's part of life. The point is how we're gonna understand and solve them. If we have the context of having all the tools and the environment of security, if I can say that, security, that there is a place where I will be able to seek for my payment or a breach of contract or clause, whatever, in a commercial dispute. I won't be afraid to do business with different countries. And this is the scope of the Singapore Convention. And that's why requires being written and is only commercial and is resulting from mediation. What kind of mediation? Mediation is a process where the parties seeks a third party to assist them to reach the solution. It's not the parties talking to each other directly. The point is there is a third party intervening in that process of negotiation. And there is another point very important to say: the importance of certifying mediators and the mediator training and the trust. Remember from the beginning, I mentioned that because I won't read here all the articles of the Singapore Convention, and if there is anyone interested, please email the center after. I will be more than happy to answer questions. But one of the aspects that the mediation agreement can be challenged and not enforced is there is a breach of the mediator, and there is an ethical breach of the mediator, or if someone is able to prove that the mediator did not comply with the ethics and the standards. So this is very important to show once more the importance of the trained and the certified mediator. And I am mentioning the certified mediator because more than having training and more than having the theory and the practical hours of training, and just because the market and the context of lawyers and the centers of dispute resolutions understand it's important of the mediator to be trained and study, they create a kind of certification of best practice. This certification of best practice is after being a trained mediator, after having the certification, after completing the theory program course and the practice hours, after doing all of this, there is another certification, another kind of test to show the skills of that mediator. And we have a lot of centers having this certification. We have the IMI, the International Mediation Organization, because the dispute resolution word and the market understand is good to have a kind of a standard of behavior, a standard of good practices for the Institute of Mediation. Is not only the person A, B, or C. If that person A, B, or C is a certified one, which means pass the long way of having trained, being trained, and after the training did the certification process, it means this person acting as a mediator applies during the process of mediation, applies the good work, the good standards, applies the tools that have learned, apply the communication skills, apply the negotiation skills, and is expected to do a good job. And doing that is spreading the good solution, the amicable settlement, the amicable solution, the fastest solution, the less expensive solution. And this is develops the institute of mediation itself, not only the person, not only the center. And this is why selecting trained and certified mediators is useful and important, because is a kind of showing that will be done a good job, better than a person that might be someone that understands that issue. Imagine a corporate problem. Okay, I'm gonna ask a very famous corporate lawyer, and I trust this lawyer. I know he understands shares and corporations, and I'm gonna ask him to be the mediator. He understands corporation and corporate law. And how about communications and negotiations and talking with one party and caucusing and joint sessions and separate sessions? And so knowing the topic does not mean knowing the tools. But in the other hand, if the mediator is a trained one, knows the tools, knows the topic, had the training, etc., and besides that, understand the market, understand the issue of the conflict, is the top. So selecting the mediator is going to be a good mediation, having a family mediator for commercial and business disputes. Okay, once mediator, always mediator, is trained, the standards, the tool. Okay, all of this will be there, will happen. But knowing the words, how the market goes, the habits, and knowing the topic and the aspect of the commercial dispute, this is my very particular point of view, is much more interesting, and it gets the mediation faster and gets the mediation to reach a solution, because the mediator will be familiar with the words, if how the context and how that business or the problem works, and even for asking the right questions. So in my particular point of view, it's a gain, it's a advantage knowing the topic. But I understand there is the other point of view from other person, a different one, that defends one's mediator will be able to mediate any kind of dispute and any aspect. And is that right? Will be able, but will be better if knows the topic, will be more faster, will be more deeper questions. So is in that aspect that I am mentioning. So besides being trained and being certified and having that interview with the mediator, selecting the style of the mediator and understanding why this is so important, because if you, especially in international and business context, that I guess there is the topic that interests most the audience here, this is very important, because if there is any misbehavior of the mediator, it's an issue that might not be enforceable, the settlement agreement, according to the Singapore Convention. So having all this said, and all these topics and reflections I am sharing with you, we have the international mediation certifications. We have one in Brazil. We have the other international ones in London, United States. I am a member of a Brazilian center for Lusophone language, for the Portuguese language, not only in Brazil, but in Africa, and in every country that speaks Portuguese language will be able to be certified according to that Portuguese-speaking language, according to the international standards. But in Portuguese, does not need to do the certification in English. And this Brazilian center is linked to other centers. This is the Brazilian one I mentioned, is the Institute for Certification and Training of Lusophone Mediators, the ICFML. And it gathers all of these institutions, the Singapore International Mediation Institute, the Asia Mediation Center, the Institut Français de Certification des Mediateurs, the International Dispute Resolution and Risk Management. All these institutes started this Alliance for Mediation Standards, because recognizing the importance of having the mediation standards apply in every part of the countries, and having these mediators working in this kind of standards, I won't say patterns and I won't say styles. Applying the quality standards does not mean all of mediators work in the same way. They apply the minimum quality standards. But if ask questions like A or B or C, this will be mediator style. So please do not misunderstand quality standards for standard of style of mediation. Is completely different. I am not asking for all mediator to act and behave in the same way, but applying the minimum standards, it's a very good way to practice and work. Explaining to the parties in the beginning of mediation how the process will work, explaining to the parties the style of the mediator, asking parties if they have any doubt of the process, how it's going to be, how they like most, if they like separate sessions, joint sessions, one day, once a week, asking the parties if they have authority to be there and to settle, ask the parties if they need other one from the company or from the business authorization to settle up to that amount or the other amount. So starting set a lot of things makes the mediation and the session and the future encounters go smooth. So this is the minimum, the standards, and the importance of knowing the one you are selecting for your conflict. And this many times is done in a joint job, the company and the legal department, or even the third party lawyers. So if the company does not know where do I gonna seek for mediator, do I look for some list, or do I ask your lawyer, or in our case, go to the center. We have the Brazilian contacts in Rio de Janeiro. The center specialized in solving conflicts, the import and export conflicts and business conflict through mediation. The center, I once more thank for the invitation to be here. And thank you once again for the Mediation Center, the CAEB Mediation Brazilian Center. And I guess this is it. And please feel free to send questions if you have. Thank you once more.